commerce. Other than that, I will pass it over to Marcel, and you are more than welcome to take it away. Thanks again.
Thank you, Eric, and everyone at Enactus. Thanks for taking time out of your busy day to listen to a little bit of the world of intellectual property. Hopefully, I'll be able to help you navigate that world, which can be sometimes difficult to do. So the presentation today is general information, and it's not intended to be a substitute for advice by an IP professional. The reason being, every situation has to be looked at. Each factual situation has to be looked at and assessed in order to then provide some sort of strategic plan to deal with your specific situation. Today, we're going to look at forms of intellectual property, some strategies that you can implement, and then there's a little quiz at the end just to make sure everyone is awake and paying attention. Eric said that it'll count to about 80% to your final grade or something. I think that's what Eric said. I'm just
It's a
joking,
question on
guys.
final reporting in April,
Yeah,
guys.
yeah, just joking. And then the last question on the quiz, so you can prepare for it now, is who's going to win tonight's baseball game. So, okay, now we're dealing with IP. This is a really busy slide. This will be available for you after the presentation. The one thing I want you to take away from this: why intellectual property? Why look for securing IP? The key things that can generate revenue because IP is an asset. It can be licensed or sold. It also assists in asset valuation. So when your business is being valued, the more IP you have, the more value it can be attributed to the intellectual property that you hold. And there's also the opportunity to expand globally. The more IP that you have in various jurisdictions, the more likely investors will come to you and be more incentivized to assist and invest in your global expansion. So here are the forms of IP that most people have heard of. So there's a patent, a trademark, copyright, industrial design, and a trade secret. So first one here is a patent. This patent here issued many, many years ago. It is for a balloon with some advertising attached to it. But what is a patent? So it's an instrument granted by the government. In this case, we're talking the Canadian government, which gives you the right to exclude others from making, manufacturing, using, and or selling your claimed invention for up to 20 years from the filing date. In exchange for that monopoly, we provide the patent office with a complete description of your invention. Now, why should we provide a complete description of your invention? You may say, or you may think that, well, I don't want to give that away. I want to keep it to myself. So the system is designed in such a way that if you want a 20-year monopoly, then you provide that complete description. The description is complete such that it provides enough information so that someone in your area, so in the area of the invention, let's say it's in the area of chemistry, would be able to pick up the patent, read it, and replicate the invention without any undue experimentation. So they wouldn't have to sit there and say, something's missing. I don't know. It says add A and B and stir for 50 minutes, but it never says what the temperature is, right? Unless it's understood, right? Add A to B, heat water to boiling, and then stir. So then you know, right? But if it just says add A to B and stir for 50 minutes, and you say, well, I don't know what temperature, and then you have to start doing some experimentation that isn't routine, then it could suffer from insufficiency of disclosure. The other reason is for that complete disclosure is if the system was created in such a way to not only benefit the inventor for coming up with something new, but also to allow others to read what you've come up with and also improve upon what you've come up with. The basis is the more we read, the more we improve on technology, the better our lives should be. So that's the other benefit or reasoning behind the patent system, not only to benefit the inventor, but to benefit society as a whole. The term of a patent is 20 years from the filing date. It cannot be renewed after 20 years. Once that patent is expired, it becomes part of the public domain. When you file an application at 18 months after the filing date, your application becomes published. That doesn't mean that the patent is granted or the patent is allowed. What it means is your application is published and there is available for anyone to read and do with it what they want. They can use it as part of their R&D to improve their R&D, or if they read it and they feel, hey, this invention should not be granted because I know it was already done 5 years ago and I have the evidence, you could then file a third party protest and file it with the patent office to say, this is the reference that was granted or issued or published long before the filing date of this application, and it teaches the claims that the applicant is seeking, and therefore it should not be granted. The examiner will take that into consideration. When your patent is granted, so if you file for a patent in Canada and it's granted in Canada, it will be valid and enforceable in Canada. It will not have any impact beyond the borders of Canada. If you're looking for protection in other countries, you then have to file in each individual country. There are some regional patents, European patent, which includes a number of countries in Europe, but typically, if you file for a patent in Canada, it's granted in Canada. It does not go beyond the borders, does not extend beyond the borders of Canada. And as I mentioned, once your patent has expired, the invention as claimed becomes part of the public domain, meaning anyone can replicate and practice the invention without fear of infringement of the claim. What are the minimum requirements for you to obtain a patent in Canada? It first has to be new, meaning no one has ever done it before. It also has to be inventive or involve an inventive step. It can't be obvious. So, for example, replacing a nail with a screw to fasten two pieces of wood together, and you argue that, hey, with a screw, these two pieces of wood stay together longer. That would be considered obvious because it's an inherent property of the helical fastener that it's going to grip the two members together longer. And the third requirement, it has to be useful. And it has to fall into these categories. It has to be art. And when I say art, I mean art of chemistry, art of engineering, art of welding. Process could be a machine, it could be a manufacturer, or it could be a composition of matter and improvements associated thereto. In the United States, what's important is a declaration of inventorship, meaning when you file a patent application in the United States, you declare that the patent application was either made by you or authorized to be made by you, and that you are the original inventor or original co-inventor, and you understand that any willful false statement made in that declaration is punishable by a fine or imprisonment or both. Now, in the United States, that's mandatory. In Canada, we have what is called a Declaration of Entitlement, and your agent can complete that on your behalf. Similarly, in Europe, your agent can complete that on your behalf. But in the US, it is mandatory. An industrial design is an instrument granted by the government giving you the right to exclude others to produce or reproduce your design throughout Canada for up to 15 years. Now, this design that you see here on the screen is actually a design that was in Canada granted in 1868, and it has to do with the pattern, the stitching pattern you can see on the bottom of the shoes. So you'll see how the leather sole of the shoe is stitched on. And a design was granted for that stitching pattern, right? Because it's the aesthetic, the visual features of that design. It has nothing to do with the functional elements. We know that stitching the sole to the size of a shoe, there's definitely a functional aspect behind it, but we're not protecting that functionality through an industrial design, but rather we're protecting the visual pattern or ornamentation. Here we look at a trademark. So this was the first trademark that was granted in Canada, and it was granted to a tobacco company. Here, a trademark is granted to you to use the mark throughout Canada in relation to the products and services that are associated with the mark for a period of 10 years. Now, here you see that the trademark is renewable. If you recall the patent slide, it said 20 years and then you're done. Industrial design, 15 years and then you're done. A trademark, 10 years, but renewable, which is why actually this mark, apparently the colonial mark, is still registered. They have been paying the renewal fees since 18 something. Coca-Cola, for example, is a registered trademark that's been around for many, many years. So a trademark, unlike patent and industrial design, can be renewed. What can you register as a trademark? You can register a word or words, a logo, slogan, sound, or combinations of these. One sound that is registered is the MGM Lion's Roar when you see at the beginning of a movie. Another sound is the Harley Davidson motorcycle. What's important with your trademark is you need to identify your trademark. If it's a non-registered trademark, it should be identified with a superscript uppercase TM following the mark. If it is a registered trademark, then you identify it as a capital R in a circle following the mark, the registration mark. Now, trademark is a federal mark, federal business mark. It's not a domain registration and it's not a corporate name registration. So don't get confused if you get a domain registration that it gives you the right to use that mark across Canada. That's just a domain registration is simply that, the registration of that domain name. A copyright here is an instrument issued by the government granting you the exclusive right to Produce or reproduce your work, be it literary, dramatic, musical, and artistic work. Code, computer code, falls under the category of literary work. So if you have a code, computer code, it would fall under literary work. The term of a copyright is the life of the author plus 70 years. Copyright, unlike a patent, an industrial design, and a trademark, is automatic. So if you are the original creator of a literary work or artistic work, you inherently have ownership of that work. Registering your copyright with the Copyright Office gives you archive protection, and then you have an official document from the Copyright Office should you need to use it in any litigation or in a dispute. If you are the original creator of your work, you should properly mark your work. So C in a circle, your name, 2025. Now, with the trademark, you couldn't use the R in a circle unless it's a registered trademark. Here with copyright, because ownership is automatic, is inherent by the original creator, you can use C in a circle, owner name, and the date. It doesn't imply that it's registered or not. Trade secret. So a trade secret is not a government instrument. This is something that you would keep confidential, and it's information that gives you some sort of advantage in the business world. But for it to qualify as a trade secret, it has to be kept confidential. How do you keep it confidential? You have confidentiality or non-disclosure agreements and licensing agreements in place to ensure that whomever you're sharing that trade secret with, it could be a contractor, a manufacturer, a distributor, that they're going to keep it confidential through these agreements. If they breach the agreement, you can sue them for breach of agreement. But if the trade secret is out, it's very difficult to bring it back and keep it confidential. So you have to be careful with a trade secret, because once it's disclosed, it's no longer a trade secret. Here are some well-known trade secrets. There's a Blackburn's baseball rubbing mud, so I wonder if they'll be using that in the game tonight. This here, and on this slide, is an example of many forms of intellectual property that you can find in a single item that most of you likely carry with you and use frequently. So your smartphone. So how does a patent relate to a smartphone? It relates to the functional aspects of a smartphone. So in this case, it could be a touch screen or it could be a flexible screen. Trademark, how does that relate to your smartphone? Well, then it's the name of the phone. So either Google's Pixel or Apple's iPhone. Industrial design. In this case, I make reference to a raised keyboard. Some of you may remember, some of you may not. Uh, the BlackBerry had a raised keyboard, so that would have been protected through an industrial design. The rounded corners or profile of your device can also be protected through an industrial design. Copyright. Copyright with your smartphone would relate to the operating system. And you know, when you want to replace the battery on your smartphone, so you take the back off and then you got to take the adhesive protective covering off, and you finally get to the battery, and then you see around the battery, you see the circuit, integrated circuit. That can be protected through an integrated circuit topography. So smartphone is one example of many forms of intellectual property that you carry with you on a daily basis. This slide here provides a summary of the IP instruments that you can use. So patents deals with utility, functional, up to 20 years, trademark, word, logo, slogan, up to 10 years, renewable, copyright, artistic literary works, life of the creator plus 70 years, industrial design, aesthetic features, up to 15 years, trade secret, confidential, and the term is indefinite. Now we're going to get into some strategies. Um, what's important when you're looking at filing a patent application is to file the application before any public disclosure. The reason being, even though Canada and the US, most industrialized countries will have a 12-month grace period, meaning if you disclose today, you can file for patent protection within 12 months, and your public disclosure will not bar you from obtaining a patent. But other jurisdictions, they don't have that 12-month grace period. So, for example, Europe and Japan, they have absolute novelty, meaning you must file before any public disclosure. So, if you don't know what your markets are when you're starting this process, you may not want to jeopardize losing the European market or the Japanese market because you've disclosed before filing a patent application. One way to mitigate that disclosure is to file a provisional patent application in the US. Usually that's done if you're coming up to a trade show or you're coming up to a competition and you're going to disclose your invention. So before that disclosure, you file a provisional patent application with the US. As long as what you're going to disclose at the trade show or at a competition is covered and is contained in the provisional application, then you're free to disclose. Because that provisional application can then be used as a priority document, so you can piggyback off of that provisional when you're filing a formal application. If you don't know what your markets are, another option, and many of my clients do this, is they file a PCT application. So it's an international application, which 158 jurisdictions recognize that filing date. You can file it, that PCT application, with the Canadian Intellectual Property Office. And once you file that application, you have up to 30 months to defer major costs of filing, examination, grant fees, etc., in those 158 jurisdictions. So during that 30-month time period, you could be looking at investors, researching markets, lining up manufacturers, right? So then you can say, okay, at T equals 30 months, we know our market is the US, Brazil, Mexico, and Germany, let's say. So now you know you want to focus on those countries. One other benefit of getting that 30-month deferral is within that 30-month period, you're going to get a search report from the International Searching Authority, and you're going to get a written opinion on patentability after they've examined the claims. So you'll get a good picture of whether the patent office will grant those claims. You could then use that positive report in any of those 158 jurisdictions to say, hey, the International Searching Authority found that it was patentable. Therefore, I'd like you to consider that when you start your examination. Investors also like a positive written opinion on patentability. Some other strategies to think about is in Canada, or Canada is part of the Patent Prosecution Highway Program. Now, the Patent Prosecution Highway Program, countries become part of that. And if you have an application in Canada, let's say in the US, let's say in Europe, and the European Patent Office has finished their examination and deemed your patent claims allowable, you can then use that positive report as well, give it to the Canadian examiners, give it to the US examiners, and say, hey, these claims are the same claims that we filed in Europe, and therefore, please take this into consideration when you're examining the claims. Typically, what that'll do, it will accelerate the examination. The beauty of it, that there's no extra charge from the patent office when you're requesting entering the PPH program. Another program that is available in Canada is the Green Fast Track program. So the Green Fast Track program allows accelerated examination of your application as long as the technology and the commercialization of that technology resolves or mitigates impacts on the environment. So when you work with your patent agent, you want to draft the application in such a way that it could be construed to help resolve or mitigate impacts on the environment. And then that will qualify you to a fast track examination program. Here's a roadmap that you may want to think about when you're starting a business or you've come up with an innovation. Make sure that you clear the use of any trademark or technology before you go down that road. What do I mean by that? If, let's say, you want to call you've come up with a soft drink and you want to call it Coca-Cola, and you didn't know Coca-Cola existed. If you started using Coca-Cola, you would likely get a letter from the lawyers, legal representatives of Coca-Cola saying, cease and desist, you're infringing our trademark. By doing a search first, it will come up with a list of trademarks that are identical and or similar to what you want to use. And then that at least can help you decide whether you want to change the mark or you're going to pursue that mark as you want. Same with technology. You want to make sure you're not infringing someone else's patent by the technology that you may have come up with independently, but there may be already a patent covering that technology. When you're in a situation where you've been employed by company A and now you're moving to company B, check the employee agreements. Make sure there's nothing there restricting you from taking any know-how that you had in company A to company B. You want to make sure that you're not breaching any clauses in the previous employment agreement. Create an intellectual property policy. So what I mean by that, you want to create a policy such that you will like to let everyone in your team know that you take your IP seriously and you're going to control the IP and you're going to do everything possible to ensure that the IP is protected. One way of doing that is making sure employees sign agreements relating to IP rights. Make sure that's done right off the bat, and this way you're mitigating any issues down the road. Identify um, identify any potential IP that you may have. So what I would suggest is you have a meeting with your team every quarter and say, okay, what are we working on? Anyone come up with new names? Anyone come up with new designs? Anyone coming up with new technologies? Right? So you got to go through that and have that conversation and then identify any IP that could be relevant. Have confidentiality agreements or non-disclosure agreements in place. We already talked about that. I think it's important. Prioritize IP protection. Many times when you have a startup, startups are concerned with, I want to get MVP, I want to get to the market, and I'm not really thinking about IP early on. Problem is because we have that 1 year period for, let's say, for patents, and even with trademarks, first to file will get that trademark. It's difficult to come to a patent agent 5 years after the fact, say, hey, this is selling. We're making a lot of money. We want to protect it now, because now you've gone beyond that 1 year window that we talked about earlier on. You want to monitor your competitors' intellectual property. What are they doing? Are they doing something similar to what you're doing? Maybe they're infringing your intellectual property rights. So it's always good to know what they're doing. And I'm not saying go in and hire a private investigator to do what they do, but just monitor what they're doing. People like to post things about themselves and their business, press releases, etc. And that's one way to monitor your competitors' intellectual property usage. And this roadmap, you need to reevaluate. You can't, it's not a static process, but it's something you need to do frequently. I would suggest at least every 6 months. Here are some pitfalls. We talked about public disclosure prior to filing a patent application, and the ramifications. Canada and US, we said, has a 1 year grace period. Many countries and jurisdictions do not. If you use the name or technology without prior clearance, you could, a search for that could be maybe $1,500 or $2,500. Not doing the search could cost you $50,000 or $250,000 in damages. So it's worth incurring that cost up front to get a clearance to use a trade name or technology. If you, oops, if you know someone is using your intellectual property and you're not doing anything about it, and then 6 years down the road, you say, okay, now I'm going to sue them for patent infringement. That may not be the ideal situation, because there are statute of limitations that you need to be aware of. Every province is different in terms of statute of limitations. You need to initiate legal proceedings shortly after finding out that your competitor is using your IP. And don't avoid professional intellectual property counsel. Universities and colleges have commercialization offices. They're very helpful. They have a broad understanding of the importance of IP. They work with intellectual property specialists. So it's important that you engage with them. If you're in a situation like this where someone comes in to speak with you about IP, don't hesitate to ask questions. If it's in a group setting, I would say keep your questions general. Don't be specific. You don't want to disclose something that could be confidential and could be deemed public disclosure. I'm going to show you, this is an industry example, just so you can get an idea of the importance of IP.
Protecting your idea and how you execute your idea, I think, is extremely important. The team that built and is building Nevex. In one of our earlier ventures, we actually invented what's called network address translation. It's a feature that's in every router sold in the last 12, 15 years. And we were young at the time and green, and therefore we just, we didn't protect it. We didn't have the money to, and we didn't have the experience to. This time around, and what I'd advise everybody to do is, when you have a really good idea, make sure that you understand how you want to protect it. There are a number of different options. The ones we've chosen are patenting, just as a defensive measure, if nothing else. And even though, actually getting a patent and maintaining a patent is very expensive, starting the process is relatively very cheap. you can get something called a provisional patent, which gives you a priority date on your protection for your ideas. And that can range from a few $100s to a couple of $1,000 per, which should be manageable if your idea is really good. And what that really does is allow you to defer the decision about whether to spend more money patenting your intellectual property. And I think everybody needs to start that way, so that once they see whether the company will work, if they have enough money to spend on it, they can then take the decision to go further and properly protect their ideas.
So there are a couple of things in that video. There's no such thing as a provisional patent per se. There's a provisional patent application that you need to do something with it within 12 months. Otherwise, it's of no value to you. And the numbers that he gave from a couple of $100s to a couple of $1,000, those numbers are off. This is an old video. But the one key thing here, a couple of key things to take away, is to think about IP early on. The reality is some startups don't have the funding, but what is nice, you're going to see in the next few slides, that there are funding opportunities both at a federal level and a provincial level that startups can take advantage of to help with their IP protection. So if you've developed something new or improved on something, what can you protect through IP? So through a patent, you can protect the product itself. You could protect the process to make the product. You can protect the use of the product or the application of the product. You could protect perhaps the microstructure within the product itself and any improvements related thereto. Other IP options: your original literary work, product description can be covered through copyright. The name or logo or slogan is through a trademark. The aesthetic features or pattern of the product is through an industrial design registration. So in Canada, it's called an industrial design registration. In the US, it's called a design patent. For the utility aspects of your innovation, it's through a patent. The key thing here is take a holistic approach to protecting your intellectual assets. A patent may not be available. An industrial design may be, a trademark may be, a copyright may be. So don't get discouraged if a patent isn't available. I wanted to touch upon this. So this slide here talks about the federal government program, Elevate IP, that you can get up to $300,000 in grants to help protect your intellectual property. The program right now is closed, but they're talking about opening it up again in April of 2026. For Ontario's Intellectual Property Ontario, they grant up to $300,000 with a co-investment of 20% by the client. National Research Council has a program that'll provide you up to $30,000 for preliminary searching, reviewing, and assessing your invention. Can Export has up to $50,000 to help you cover the costs in protecting your intellectual property beyond the borders of Canada. So if you know Europe is your market and you want to secure your IP in Europe, Can Export will help in that regard. This is some of the requirements to be eligible for the Intellectual Property Ontario. You have to be based in Ontario, less than 500 employees. You have to fall under either health technology, life sciences, AI, vehicle tech, mining tech, agriculture and food tech, or clean tech. You have to own the IP to show that the business is going to bring social or economic benefits to Ontario. And you need to operate in Ontario with the intention to grow the business in Ontario long term. For Elevate IP, You have to be a Canadian controlled private corporation, less than 500 employees. Again, the IP must be owned or will be owned by you, by the company, by the private corporation. You have to be headquartered in Ontario, Manitoba, or Saskatchewan, and you work with either Communitech or Invest Ottawa and North Forge. Other Elevate IP programs across Canada. So this will be for Atlantic Canada. They have their own program. You have to be based out of Atlantic Canada. This is for Western Canada, British Columbia, Yukon, Northwest Territories, Nunavut. Quebec has their program as well through the federal program. You have to be based in Quebec. Alberta has their own program as well. You have to generate less than $10 million annually, less than $1 million in dilutive funding raised, associated with an Alberta-based business accelerator. So you can see that every region has their own requirements. So some key information that I want to share with you as well, from the patent side of things. Everyone's talking about artificial intelligence, right? Generative AI. A patent inventor must be a natural person. It cannot be generative AI nor a legal entity. This was a decision that was rendered recently by the Commissioner of Patents in Canada. If there is a Canadian patent and you're making and using the claimed invention outside of Canada, well, then there's no infringement of that Canadian patent. It has to take place within Canada. Patent fees are essential for you to keep your patent and your application in good standing in Canada and most industrialized countries. In Canada, the fees, the annual fees, should be paid on time. If you don't pay them on time and you go beyond a certain period where they allow for payment with a late fee, you then have to show due care. And that is a very difficult test to meet. To tell the patent office, I didn't pay the annual fee because I didn't have money at the time, that won't cut it. It has to be an act of God, or we're in the middle of a war, or you were sick and in a coma for months and there was no one there to deal with your legal affairs. That they may consider um, um, a valid reason for not paying your fees on time. So I tell my clients, budget for your fees and make sure you pay them on time, or else you lose your patent. So now I have a quick quiz. So feel free to, actually, before we go to the quiz, let me look at those questions, if that's okay.
So Marcelo, I know the first question was,
How do
so
I
I know
make
you
sure?
touched on it, but how do I make sure there are no other ideas similar to
Right.
the business wanting to be patent?
Right. Great question. So that would be doing that clearance search that I mentioned. You speak with a patent professional, you speak with an IP professional, and you say, by the way, patent agents are bound by confidentiality through federal statute. So when you do meet with a patent agent, a registered patent agent, when you share with them what you have, it's bound. We're bound by confidentiality by statute.
Okay.
So how do you know there are no other ideas similar? You do a search. You do a search yourself, or you hire an agent to have a search carried out, and then the results will be shared with you. Um, this is the next one, I think, Michaela.
Yes. Yeah.
How difficult is it to change your patent if you end up making an improvement to your process of making? Okay, good question. I think there's a number of questions in there, Michaela. When you file a patent app, at least when I work with my clients and you file a patent application, I ask for as many alternatives to the invention that you come to me with possible. So you may come to me with A plus B at 20 degrees Celsius to get C. Then I'll say, okay, can we combine A with something else to get C? Can we combine A plus B at a different temperature to get to C? So when you're working with your patent agent, they're going to ask you these questions to allow you to provide alternatives and expand on what you've described so you can then include that in your original application. Now, pharmaceutical companies, for example, aspirin, there'll be a patent on aspirin. Now they want to extend their IP. How do they do that? Well, now I'm going to make an enteric coated aspirin. And then after that, they say, well, now let's make a aspirin transdermal patch, right? So when you talk about improvement, Michaela, there has to be an improvement such that it's new, inventive, and useful. It can't be something that would be considered obvious, right? Where can we, Crystal, go to search for trademarks? So you can go to the Canadian Intellectual Property Office. They have a public database that you can search trademarks and patents. Inez has, when is the best time to start including IP? Right from the start. If you looked at that, heard that video of that gentleman, they weren't really thinking about IP and thinking about patents. And then all of a sudden, they realized that everyone and anyone was using their IP. So that's important. So I think we have some time. We can go through this quiz quickly. You developed a new process and tool for removing contaminants from water. Just using the chat box, what should you be seeking? A patent, trademark, copyright, or industrial design? Right. So it's a patent. So remember, a patent may be granted for a product, a process, a composition, or an apparatus or improvements to the above. You've now invented a product and you'd like to post on your TikTok a description of the product and how it works. What do you do first? File your patent application first and then do your TikTok video and post it, or do your TikTok and then file the application? Yes. Yes, you're right. File the application first and then post. And remember, the reason being, even though Canada has a 1-year grace period, other jurisdictions do not. So it's always best to speak to a patent agent and seek advice before any public disclosure to avoid risk of loss of any IP rights. And when I say public disclosure, if you say, I've come up with a composition where I can uh, color the gray hair to black hair, but you're not saying how you do it, that's not really a disclosure. A disclosure will provide enough information such that whoever hears it would be able to replicate your invention without undue experimentation. Now you've come up with a unique shape for the tool. So for that unique shape, what should you be looking for? A patent, a trademark, an industrial design, or a copyright? So in this case, it's actually the industrial design. Remember, the industrial design protects the shape, configuration, pattern, or ornament, or a combination of these. We're looking at the visual appearance of the product. Someone had put in copyright, but we'll deal with that in a second. So you decide to name the tool Crystal Clear. So if you've got a name for that tool, what should you be looking for? So in this case, it'd be a trademark, right? So the trademark could be something that is associated with your product or services in the marketplace. And remember, we talked about a search is always recommended before you start using the mark. So now you've written literature describing the tool and the process. So what should you be seeking? If you've got your original written literary work. So in this case, copyright, right? So you can register the copyright, or remember, copyright is inherent. So we've done questions. This is my information. If you want, feel free to take a snapshot. I'll provide to share the slides to the folks at Enactus, but I'm going to stop sharing now, and then let's see if there are any other questions. No, I don't see anything else. So, Eric, it's up to you.
Sounds good. Well, firstly, just wanted to, oh, sorry, as I was saying that, Crystal just asked, does code fall under copyright?
Yes. So remember I said computer code is literary, a literary work, so it would fall under copyright. Now, that's the code itself, Crystal. But the code, what is the code? Is a series of steps. So if it's a series of steps going from step A to step F, let's say, for example, by crafting those steps and describing those steps in such a way that it's just a process of analyzing data. Step 1, input of data. Step 2, analyzing. Step 3, optimizing. Step 4, looking at the possible options based on that data. And step 5, providing the user with the ideal path based on the data. That's patentable. We've described the algorithm as a series of steps. Algorithm itself is not patentable. That's copyright, but the series of steps can be protected through a patent. I hope that answers your question, Crystal.
It does. Can I follow up? Sorry, it'll take me a while to type, so I'll fully unmute. So does that mean that some organizations could, I guess, have multiple forms of IP? So I guess the code there would have the copyright, but then the steps would also be patented there.
Correct. That's where I mentioned taking a holistic approach, right?
Yeah.
So if you saw my quiz, it was all about the same tool.
Right.
Covered by patent, covered by industrial design, covered by copyright, covered by trademark. So always think about, if the budget is there, taking a holistic approach. And with those programs at the federal and provincial level, the factor of I can't afford it has sort of been pushed aside, because now there's that opportunity to get the grants to then move forward and protect your IP.
Sounds good. Man, that's expensive, but good to know.
Thank you, Crystal.
Thank you.
I have a question too, if I could ask.
Sure.
First of all, thank you so much for making the time to talk to us. I learned a lot of good things from you. Second, I wanted to ask, so like I have this project, this idea, and I found out the problems with it and where I can bring my own idea into it. And right now I'm at a stage of like talking to like, so my field is in the hospital, so like I have talked to the pharmacy people and the president and stuff, and we're planning on making a pilot project on this, just a very short small baby step for this bigger thing. I don't know, does that mean I have to start thinking about patenting this, even this small project that I'm working on right now for a couple of months, or I'm not there yet? I don't know.
Well, it depends, right? If you're at a stage where, first of all, in talking to all these people, you should have a non-disclosure agreement in place. That's the first thing. And in carrying out these projects, if it's experimental to see, is it actually going to work? Then it may be a little too early, because you don't know if it's going to work or not. Once you've confirmed that it works, then I would definitely start looking at the patent process.
So you mean like after the piloted project of, let's say, the 3 months, if I see if that works, that's when I start doing
Yes,
this?
because if you file something now and it doesn't work, then you're lacking utility, right?
Yeah.
So the patent office is going to say, where's the example? You can't patent an idea. You have to have
Mhm.
a problem and a solution, and then you have to show how to get from the problem to the solution. Um, and I think that's where the pilot program is going to, the pilot study is going to show you whether you can get from point A to point B, correct?
Yes.
Yeah.
Thank you.
Thank you for your question, and good luck with your pilot program.
Amazing. Did any other students have any questions at all?
I have a question.
Perfect.
I'm going to put it in the chat box.
I love it.
There we go. Somebody
Yes.
gave the right answer right away.
Yes.
There we go. Good. Good.
Yes. All our favorite students now. I'm just going to stop the recording and go from there.